Welcome to today's video. I'm Richard Chapo. I'm a privacy lawyer in San Diego, California. And I thought today we'd talk about why the United States needs a national privacy law. Now, you may already have a theory on this or a view, and I just want to state that you should listen to the whole video and then rethink potentially your position. It may not change, but hopefully you'll at least understand there's two sides to this argument. So the United States is one of the rare first world countries that does not have a general national privacy law. Now, we do have them for some specific subjects like medical records. You probably heard of HIPAA, but not a general national privacy law. And in comparison to other regions like the European Union with the GDPR, that's considered very odd. And in fact, when other regions look at us from a privacy perspective, you might be surprised to learn the United States almost always fails in evaluations. So for instance, Europe, before they will allow data to be moved out of Europe, there's a certain process where they have to evaluate a country and determine if it has adequate security measures for data. And the United States failed that test. And so that's why we have Privacy Shield and standard contractual clauses and other things that are designed to help Europeans protect their data. That's a convoluted subject. If you don't know what any of that is, don't worry. Just understand the U.S. doesn't have a general national privacy law, and we're considered somewhat to be in the prehistoric age on that issue. Now, when we're talking about privacy law, you are either pro-business or pro-privacy, and both positions are fine. But the problem that we have is these two parties are discussing things from an apples and orange perspective. They really talk past each other and aren't looking at the full picture, and this is causing all kinds of problems. So, full disclosure, let me tell you my bias up front. I'm a privacy lawyer for businesses. I help businesses get in compliance with privacy law. I don't do lobbying or anything of that sort, but I do help businesses comply. So I tend to be pro-business on this. But even I believe that the big tech companies need to be regulated. We need rules, Cambridge Analytica, these kinds of things we need to control a bit more, particularly when we're talking about data brokers and things of this sort where data is being moved and sold and nobody knows where it's being collected or where it's going. I think we've reached a point where, we kind of need to pull back on some of this stuff. Now, having said that, I am opposed to state laws on privacy. And the reason is because of a lack of perspective from politicians in states that leads to kind of horrendous results. So let's talk about a recent privacy law, see how this might work. California Consumer Privacy Act went into effect on January 1st, 2020. It is the first really substantive privacy law, general privacy law in the United States. And it's somewhat of a de facto national privacy law because so many businesses deal with California. Now, this law contains quite a few different unique burdens, actually even more than what you see in the GDPR. For instance, consumers have a right to tell companies not to sell their personal information, which is something you don't see under the GDPR. And so there's a lot of these big steps. The cost of compliance under the CCPA for businesses is significant. New technology needs to be created and so on and so forth. And it's very expensive. And the problem that I have with this privacy law is a problem that I have with many of them. This privacy law does not really take into account or target the correct market. So the GDPR, let's talk about the GDPR, for instance. GDPR, the European regulation, it doesn't treat businesses that are small and big differently. It does only for some record-keeping requirements, but that's about it. So if you're Facebook or you're running a tomato growing blog that has one AdSense ad on it, you pretty much have to comply in the same way with the GDPR. And that causes all kinds of problems because obviously the small company doesn't have the money, manpower, or resources to comply. Same thing with the California Act. Now, the California Act tried to build in some thresholds to protect small businesses, but the thresholds are poorly done, pretty much like the entire CCPA. It's just really poorly drafted. And so those three thresholds are, do you have more than $25 million in revenues in a year? Most small businesses are not. Do you make more than 50% of your revenue from the sale of personal information? Most businesses would say no, although that is actually kind of a tricky question because of the way they define sale in the CCPA, but let's just avoid that for now. And then the third threshold test, which is the one that's causing the most problems, is do you collect, buy, or sell 50,000 data points from California consumers, devices, or households in a year? Now, that 50,000 number sounds pretty large, right? But keep in mind, personal information under the CCPA is defined as any information that directly or indirectly can be used to identify a California consumer. Okay. So let's think about your website or app. How many people from California find your website and maybe land on a blog post or whatever and read it in a day? And how many of those people exist when you multiply it across the entire number of pages on your website? Well, remember, when somebody comes to your website, your servers are collecting personal information about them, their IP address, maybe their geolocation, maybe how they got to you, a unique identifier of some sort, whatever it may be, that counts as one. And so getting to the 137 or the 50,000 number for a year is actually pretty easy, because when you divide it by the number of days in a year, that's only 137 data points a day. And so what we're seeing is a lot of small sites who would think they never have to comply with this law do have to comply with it. And they're shocked. And this creates all kinds of problems. And here's really the crux of the issue. The compliance steps are burdensome and expensive. You may have to pay $50,000 to $100,000 in legal fees and tech and everything else to get into compliance. So, for instance, under California state law, if you have to comply with the CCPA, you have to invoke reasonable security measures. You have to take reasonable security measures for the data, personal information that you're collecting from California consumers. Well, reasonable security measures, which most people don't know, is defined under California law as a 20-step process. And that includes things like encrypting data and all these other technical steps that, full admission, are really intended for companies like Facebook and Google, these big companies. And these big companies have the time, money, and the programmers and everything else, to go comply with these laws. But the smaller businesses and sites do not. They just don't. If you're making, $50,000 a year off of your blog on growing tomatoes, you don't have $75,000 a year to go comply with all these rules and regulations. It's nuts. It's absolutely nuts. And so then the problem that we're seeing is that as the states realize that there is no national federal privacy law and they want to get in on the act, we're seeing all these states starting to come out with different rules and regulations. So California, it has its threshold test to try to protect small businesses. Well, Nevada just amended their privacy law in 2019. It has no thresholds. So all the privacy burdens and requirements apply to a business that as big as Facebook, but also a business that just started yesterday with one guy working out of his garage. So you can see the problems that this could cause. States are launching new privacy laws right and left, and we're expecting to see a bunch of them this year. And at some point, we're going to end up with so many different privacy laws with so many different requirements that a large number of businesses are not going to be able to comply from a cost perspective. But it also hurts consumers, because each privacy law has a different way for consumers to exercise their privacy rights. And one of my attorney peers was telling me the other day that he had gone through and looked at all the potential privacy laws that seemed to have a reasonable prospect of being enacted in the first half of 2020. And if everything goes through, you're going to end up going to a website. You're going to see something like 3 pop-ups, consent and privacy. You're going to have cookie pop-ups. And then you're going to have links in the footer of the website, something like 12 links talking about different privacy rights and everything else. It's just going to be chaos. This may all sound good to you if you're a privacy advocate, but let me ask you a simple question. Since the GDPR went into effect, you probably noticed cookie pop-ups on all these sites. Tons of them. How many of them do you actually read? Maybe when they first came out, you read the first couple. But now, when you go to a site and that cookie pop-up, blast up, do you read it? Do you go through and read your options? Do you go through and read which companies are serving cookies through the site? Or do you just click accept or decline or whatever button is there so that you can get to the content that you wanted to see? And the majority of people just click a button just to get the damn thing off the screen so they can see whatever content they've come to view. And in fact, the EU has now recognized this. They're coming out with a new e-privacy directive that will deal with cookies. And one of the first findings that all parties agreed to is the cookie pop-up idea is just a bad one. Because it's lost all effect. There's what they call cookie fatigue, which means exactly what we're talking about. Nobody's reading these things. They're just clicking whatever button it takes to get them off. It's kind of like the warning on your mattress. Have you really sat down and read that warning? Probably not. So that's the problem that we have. So how would a national privacy law solve all of this? Well, the benefit of a national privacy law is that it is the law of the land. If it is a federal privacy law, we have something called the Supremacy Clause in the United States Constitution. And what that says is that if Congress passes a law on a particular subject, it is the law of the land regardless of whether there's a state law or not. So effectively, the state laws on privacy would all become void, and you would have this one national privacy law. And the beauty of it, whatever your politics are, whatever you want the national privacy law to say, whether it was really strict or is really loose, whatever. I'm not talking about that, just that we need something. Because if we have something, then we would have one set of rules for the entire United States. And then we would have, the ability for entrepreneurial Americans to create tech to support that privacy, those rules. Compliance, so that small sites could just have a plugin that they went and got stuck on their site, and it got them into compliance. Ironically, this is one of the reasons the GDPR in Europe was passed and put into place. Because in Europe, the problem that they had was each country, they had what originally was called a directive on privacy. A directive is not specifically binding on countries. It's more like a suggestion of themes that should be incorporated into the member states' laws in Europe. And so you ended up with 28 different sets of privacy laws, and it was chaos and nearly impossible to comply with and total madness. And the GDPR was passed to essentially get rid of that, make things a lot easier, simplify life. And for Europeans, it has, because Europeans have already been doing compliance on those 28 sets of rules. Now they have one, they're happy. So a national privacy law in the United States would serve the same basic idea, and that would happen. Now, there are some advocates in Congress who are arguing we need a national privacy law, but it should not replace state laws, and that would be ludicrous, because then we would end up with 51 different sets of privacy laws eventually, one for each state and a federal privacy law, at which point I'd probably be moving to Tahiti and opening my Tahiti office because it would become almost unworkable. Literally, it would seriously impact your ability to use your smartphone, your PC, whatever it is that you're on, because there would be so many warnings and so many pop-ups that it would just be ludicrous. So when you hear discussions about a national privacy law, I would suggest that you should be in favor of them. Now, the question, of course, is what should be in that national privacy law? Should it be very, very strict? Should it not be? Should it be more loose? Should it have thresholds for small businesses? What I would argue is it should be pretty strict for big tech, but it should be pretty strict above a certain dollar level. Let's say $25 million a year in revenues, gross revenues, because that's a company then that's going to have resources to go out and employ tech. And then maybe there's a stage below that for companies making, $5 million to $25 million. That's a little easier to comply with from a compliance standard, money spent, time spent, that kind of thing. And then there should be exemption for companies under a certain level, say $1 million in revenues or $5 million in revenues, whatever it is, that don't have to comply. And the reason for that is those companies, really don't have that much personal information. I guess in theory they could. So maybe you throw a data number in there as well. Maybe they collect 5 million data points in a year, or 1 million, something like that. The 50,000 standard used in California is considered low. And in fact, the advocates for the law now realize it's too low because it catches things like delis. You think how many data points a deli collects in a day when somebody comes in, the lunch hour rush and what have you. Well, if they're in California and they're a deli, they have to comply with the CCPA, even though they're a tiny deli who aren't exactly, manipulating big data. So in California, you've seen an amendment actually suggested about an initiative that would bump that number up to 100,000. That's still way too low, but you can see that things are evolving. So anyway, something like that would probably be optimal. But even if it was more strict or even if it was more loose, it doesn't really matter. We just need one set of rules, because if we have 51 different sets of rules, it's unworkable. It is unworkable. So that's why we need a national privacy law in the United States. So in the future, when people are talking about it, hopefully you take into account both sides of that argument. I would encourage you to go read articles from hopefully unbiased resources, but in-depth articles about how privacy law should work. Don't go to the popular BuzzFeed sites and things of that sort, where it's just a very superficial review of the issue, because privacy law really touches pretty much all parts of commerce. So we need to think through the best way to do it. But one set of rules a national privacy law would definitely be optimal. So anyways, thanks for watching and have yourself a good one.